What's good, YouTube? It's your boy Lil Sippy back at you with another video, man. I'm kind of upset because I just made like a 25-minute record and doing this, what I'm about to do right now, and then I rewatched it and then I saw that basically I had recorded the video with my computer's webcam. I'm sorry, not webcam. With my computer's like the built-in mic into the computer, and it's basically garbage. Like, you could hardly hear what I said even if you turned the volume up all the way. So I had to go downstairs into the basement and grab this mic, and it's been sitting in there for like a couple weeks now, and it stinks. It smells like the basement. I don't even know how to describe the smell, but yeah, so now this is take two. But anyway, today I'm going to explain to you pretty much what's going on in the Daniel Larson case. I'm going to give you an overview, and specifically the federal case, right? Because he's faced numerous cases. Most of them have been disposed, but the federal case is not disposed. It's currently ongoing. It's the reason why he's in jail right now. And I want to kind of go over what's been going on in the case, clear up some misconceptions, and kind of try to break it down for you guys to understand if you're not really able to follow what's been going on in the case. But with no further ado, let's get things started. So these are Daniel's charges. These are the charges that he's currently facing in federal court. Counts 1 through 5 are use or threatened use of explosive material in violation of United States Code Title 18, Section 844 sub E. These first 5 counts of the indictment carry a maximum sentence of 10 years in prison, up to 10 years in prison, 3 years supervised release, up to 3 years supervised release, and up to a $250,100 fine. In reality, it's a $250,000 fine and a $100 special assessment, but that's really immaterial to what we're talking about right now. So, $250,100 fine, right? Count 6 is interstate communication of threats, which carries a maximum term of 5 years in prison, up to 3 years supervised release, and up to a $250,100 fine. Count 7 is use or threatened use of explosive material in violation of United States Code Title 18, Section 844 sub E, which is, of course, the same charge as 1 through 5. And that, of course, carries up to 10 years in prison, up to 3 years of supervised release, and up to a $250,100 fine. So the total maximum sentence, if Daniel was to get the maximum sentence on all 7 counts, ran consecutively, which is very, very, very unlikely. Daniel will most likely end up spending a significantly shorter amount of time in prison than this. But let's say hypothetically he gets the maximum consecutive sentence. That would be 65 years in prison, 21 years of supervised release, and a fine of $1,750,700. And to put that in perspective, if he were to get that sentence, Daniel would get off of supervised release at the age of, he would discharge from supervised release at the age of 111, if he were still alive, which is unlikely. And like I said, it's highly unlikely that Daniel will get anywhere near this amount of time, but this is just the maximum possible time that he's facing right now. And now none of the charges have been dismissed. I guess there's been a rumor, I've seen a rumor going around that Daniel's only facing 3 charges now, and that 4 of them were dropped, and that's completely false. Daniel is still facing all 7 counts of the indictment. April 25th, 2024. Daniel's indicted by a federal grand jury. This means that at least 12 members of the grand jury decided that there's probable cause to believe that Daniel committed the charged crimes. Federal grand juries typically have anywhere from 16 to 23 members, and federal grand juries require at least 12 members to vote to indict. Keep in mind that the grand jurors are only tasked with finding probable cause to believe that these crimes were committed, which is a significantly lower burden of proof than what petite jurors. When we think of a jury, we usually think of a petite jury, which is 12 jurors who must unanimously vote to convict the defendant based on the prosecution proving all elements of the crime beyond a reasonable doubt. That's a petite jury, but a grand jury doesn't have to be unanimous. Only in federal court, only 12 members have to vote to indict, so it doesn't have to be unanimous. And there's more members of a grand jury. So, like for instance, in federal court, like I said, 16 to 23 members. But yeah, so at least 12 members of the grand jury decided that there's probable cause to believe that Daniel committed the charged crimes. So he was indicted. And to give you a little backstory of why Daniel has to be indicted by a grand jury, it's because of the Fifth Amendment's grand jury clause, which provides that no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. And you probably think, oh, well, I know all these people who have been charged. Lisipi, you're lying to me. I know all these people have been charged criminally, and they weren't indicted by a grand jury. Well, I'm not lying to you. Those people were probably prosecuted in state court, which doesn't necessarily require you to be indicted. Like, a lot of people think that when the 14th Amendment was ratified in 1868, that it just automatically makes all the other amendments of the U.S. Constitution, all the other parts of the U.S. Constitution applicable to the states, and it does not. It's really, the 14th Amendment just says that states may not basically deprive anyone of due process. So it's really up to the judiciary to decide what parts of the U.S. Constitution are applicable to the states. Most of them have been held to be applicable, like, the right to counsel, right to speedy trial, right to trial by jury, blah, 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 blah. But not all of them have. And the grand jury clause is one of those that has been held to be not applicable to the states by virtue of the 14th Amendment. It's only applicable to the federal government under the U.S. Constitution. And the first U.S. Supreme Court case to decide that was Hurtado v. California in 1884. I have the citation there in case you want to go look it up in the U.S. Reporter. But yeah. And also, some state constitutions require grand jury indictment, or some state statutes as well. For instance, like in Georgia, we saw like about a year ago, Donald Trump was indicted by a grand jury there. He's not facing a federal case in Georgia. He's facing his case in Georgia is a state case, right? I don't know if it's been dismissed or not. I think it'll probably get dismissed due to the the Supreme Court ruling that he's immune. But anyway, that's irrelevant. Anyway, but what I'm saying is he was indicted by a grand jury for that case, which was a state case. But the laws of Georgia, I think the Constitution of Georgia, the Constitution of the state of Georgia, requires that that prosecution be initiated by a grand jury indictment. So some state constitutions or some state statutes require it, but the states are not required to, by virtue of the U.S. Constitution, to require grand jury indictment, and even for capital cases, and a lot of them don't. When there's charges issued by a prosecutor on his own instead of by a grand jury, they file what's called an information instead of an indictment. Sometimes it's called a bill of information, but yeah, basically an information is like the individual prosecutor version of an indictment, right? April 25th, 2024. An arrest warrant is issued for Daniel. April 30th, 2024. Daniel was arrested during a routine meeting with his probation officer. May 1st, 2024, Daniel has his initial appearance in federal court in front of Magistrate Judge Catherine A. Starnella, pictured right there. The prosecutor, Allison M. Conity, requests that Daniel be detained pending trial. To detain Daniel pending trial, the court must hold a detention hearing. The judge sets a date for the detention hearing, May 6th, 2024, at 10 a.m. Mountain Daylight Time in courtroom number A401 before Magistrate Judge Norman Reed Norder. The case is assigned to District Judge Regina Marie Rodriguez, born 1963, so she'd be about 60 to 61 years old, who was appointed by Biden and confirmed by the Senate by a 72 to 28 vote in 2021. And real quick, let me just explain what the difference between district judges and magistrate judges are. So district judges are also called Article 3 judges because Article 3 of the Constitution is what gives them their authority. But district judges are appointed by the president and confirmed by the Senate, and they have lifetime tenure, so they can serve for life if they want. Magistrate judges are appointed by district judges to basically help lift the burden of the heavy caseload that these district judges have. And magistrate judges conduct minor parts of criminal cases. Also, if both parties consent in a civil case, magistrate judges can handle the entirety of civil cases. Again, that's only if both parties consent. But in criminal cases, magistrate judges oversee just minor things, like a detention hearing or an arraignment or initial appearance, right? But anyway, yeah, and so Regina Marie Rodriguez was appointed by Joe Biden and confirmed by the Senate by a 72 to 28 vote in 2021. So she's a very new judge. She was just appointed during this presidential administration, so very new to the bench. At least the federal bench, in terms of relative to other federal judges, right? May 2nd, 2024, Attorney Jared Scott West, I'm going to assume that's Westbrook, from the Denver Federal Public Defender's Office, is appointed to represent Daniel. Westbrook received his Bachelor of Science degree from Utah State University, which is in Logan, Utah, in 2005. From there, he attended the Walter F. George School of Law at Mercer University Law School in Macon, Georgia, and earned his Juris Doctor there in 2008. He was admitted to the State Bar of Georgia on November 18th, 2008. He is still an active member in good standing. He was admitted to the Colorado State Bar on October 24th, 2011, with the Colorado State Bar number of 43973. He has since been withdrawn since the Colorado State Bar, meaning he's no longer a member. He was admitted to the Utah State Bar on March 8th, 2013, and given the Utah State Bar number of 14405, he is also no longer a member of the Utah State Bar. He was admitted to the Bar of the United States District Court for the District of Colorado on June 9th, 2021. If that if that kind of confuses you, we say, why is he no longer a member of the Colorado State Bar, but he's a member of the bar at the U.S. District Court for Colorado? What does that mean? It means he's not able to practice in state court in Colorado, but he is able to practice in federal court in Colorado, and he's representing Daniel Larson on his federal case. And right there, that's what he looks like. May 3rd, 2024. Daniel's lawyer, the prosecutor, and the judge have a conversation. It was actually on the record. I did a little more research and found out it was an on-the-record conversation, but I forgot to update the slide. But anyway, Daniel's lawyer, the prosecutor, and the judge have a conversation on the record, and it is agreed that Daniel's court date should be pushed back. Instead of May 6th, he will be arraigned on May 10th. May 10th, 2024, Daniel's detention hearing is held pursuant to United States Code Title 18, Section 3142, Sub E, Sub 1, and United States Code Title 18, Section 3142, Sub F, Sub 2. The judge will order Daniel to be detained pending trial if he believes the prosecutor has either A, proved by a preponderance of the evidence that no bond condition or combination of conditions will reasonably assure that Daniel will not flee from prosecution if released, or B, proved by clear and convincing evidence that no bond condition or combination of conditions will reasonably assure that Daniel will not pose a threat to the safety of any person or the community. Magistrate Judge Norman Reed Norder, which, go back to show you a picture if you missed it, that's him right there. Magistrate Judge Norman Reed Norder finds that the prosecution has shown that no condition or set of conditions will reasonably assure the safety of the community from Daniel, so he orders Daniel detained pending trial. May 23rd, 2024. Both Daniel's lawyer and the prosecutor raise competency and file a motion to have him mentally evaluated. Now, in criminal cases, the defense lawyer, the prosecutor, and the judge each have a duty to raise the issue of competency if they feel that the defendant might not be competent, no matter what. Even if they think it's a bad strategy decision, they still are under the obligation to do it. But what exactly counts as, competent or incompetent to stand trial? Well, the first U.S. Supreme Court case to kind of really answer that question was Dusky v. United States in 1960. Again, I put the citation there as well for you if you want to look it up. But in the U.S. Supreme Court's words, and by the way, this was a per curiam opinion, which means it was a unanimous opinion. All 9 justices concurred in the opinion, which is pretty rare. But anyway, whether that the U.S. Supreme Court in Dusky said that when basically what to consider, what makes someone competent to stand trial would be that he has sufficient present ability to consult with his lawyer with a reasonable degree of rational understanding, and whether he has a rational as well as factual understanding of the proceedings against him. And now below that I have the judge in Daniel's case from one of her opinions, written opinions in Daniel's case, what makes Daniel incompetent in her words, which is pretty similar to the words of the U.S. Supreme Court in Dusky, which is, her words were, the defendant is presently suffering from a mental disease or defect, rendering him mentally incompetent to the extent that he is unable to understand the nature and consequences of the proceedings against him or to assist properly in his defense. July 11th, 2024. I forgot to mention. Yeah. So after his lawyer and the prosecutor raised competency, they raised competency in a joint motion, meaning that his lawyer and the prosecutor collaborated and on a motion, and both said, hey, we think this guy is incompetent and he should be evaluated. And the judge ordered his evaluation. And then on July 11th, a psychiatric report is filed under seal in the docket for Daniel's case, meaning that it's not accessible to the public like most of his court records are, meaning I can't see it. The only people that could see it would be the judge, Daniel's lawyer, and the prosecutor, and anyone that they share that with, which they're probably not supposed to do. July 26, 2024, Judge Rodriguez finds by a preponderance of evidence that Daniel is incompetent to stand trial and orders him committed pursuant to United States Code Title 18, Section 4241, Sub D. Daniel will be committed for a period of up to 4 months where he will be examined and it will be determined whether or not he is likely to become competent or not. Now, a lot of the people, especially in the Reddit community of the Daniel Larson community, like to just make stuff up in terms of, well, really everything, but especially when it comes to the law. And that's why I've really tried to make sure, hey, I quote the statute, I quote the case law, I give, the citation, because I don't do the whole making stuff up thing, and I I put a source for everything I'm saying, either the statute or, the case law. Unlike a lot of idiots in the Daniel Larson community. So just quick pat on the back for me there. Anyway, if it is determined that he is likely to become competent soon, he will be held for another reasonable amount of time until he either becomes competent or the pending charges against him are disposed according to law. United States Code Title 18, Section 4241, Sub D, Sub 2. And the pending charges being disposed according to law would just be meaning somehow they get dismissed either. It could be, anyway, it could be on motion of the defense or the prosecution or on the judge's own motion, but honestly, that's highly unlikely, at least in this point in this case, right? If it is determined that Daniel is unlikely to become competent anytime soon and the charges are still pending against him, he will either be civilly committed in Colorado State Court or civilly committed under United States Code Title 18, Section 4246. And I'm not going to go into, at least not in this video, what would count. What would be the requirements for Daniel to be either civilly committed in Colorado or civilly committed under Section 4246? I think that's maybe it. You could look it up yourself, or I could do a video on it too if you want me to. Let me know in the comments below, but I'm trying to keep this. I still have these documents I want to read to you, and I don't want to make this video super duper duper long, right? It probably already will be pretty long, but going into the standards for commitment in Colorado State Court or under Section 4246 would just make it so much longer, right? But anyway, that kind of gets us up to date to where we're at in the case right now. Daniel is still waiting to be transferred to the Medical Center for Federal Prisoners in Springfield, Missouri, where he will undergo that 4-month period of observation, and they'll try to determine whether or not he is likely to become competent or not. And I think it's pretty obvious that he's not going to be competent anytime soon, right? He still thinks that Grace ordered the competency evaluation, or Tina, or somebody in the Vanderwall family ordered the competency evaluation instead of the judge. And he is, I don't know, he tells me all this stuff all the time, and I can't even remember all of his delusions, but he definitely has a ton of delusions relating to his criminal cases and what's going on in them. He's definitely not going to become competent anytime soon unless there's some type of meds, maybe if he gets on some type of antipsychotic medication. That's the only thing I could think that could possibly help. But yeah, if he doesn't get on any meds that work for him to kind of control his delusions and stuff, he's not going to be found competent anytime soon. But anyway, yeah, this is just this part of the video was just to get you up to date and kind of explain what's been happening in the case so far. Now I'm going to read some new documents in the case. I'm going to read you a motion filed by Daniel's lawyer to get the case dismissed for other reasons that have not been mentioned yet so far in this video, and I'll read to you the prosecutor's response, and then I will finally read you the judge's written opinion on that motion. And it's pretty interesting. I've skimmed through it. I haven't even read it all myself, but I'm going to read it in full today with you and try to do my best to explain everything. Obviously, I don't know everything about federal law. Even federal lawyers don't know everything about federal law. It's so complicated, so there's probably going to be a lot of stuff that I'm not able to explain, but I will try my best. But anyway, here we go. Okay, now we are looking at a document from Daniel's case that was filed by his lawyer on September 25th. And it's called Daniel Larson's Status Report and Request for Immediate Transport to a Suitable Facility. And it says, for almost 3 months now, Mr. Larson has languished in the Federal Detention Center in Englewood, Colorado, simply because he has been found incompetent, and the court has committed him to the custody of the Attorney General for placement in a, quote, suitable facility, i.e. hospital, to determine whether there is a substantial probability that in the foreseeable future he will attain the capacity to permit the proceedings to go forward. United States Code, Title 18, Section 4241, Sub D. Docket entry number DE26. The U.S. Marshals have indicated that the BOP has yet to designate a facility for Mr. Larson's restoration evaluation because it has a backlog of inmates waiting for restoration services. We got footnote 1 right there, which says the government has indicated Mr. Larson will be transported to a BOP facility in December, more than 5 months after this court found him incompetent and ordered him transferred to a suitable facility. The BOP's failure to have sufficient mental health facilities in place, thus creating significant delays for restoration services, is not new. There has been significant litigation, including in this district, centered on this exact issue. See, e.g., United States v. Castrellon, case number 122 CR 112 GPG, District of Colorado, 2023. Moreover, the delays have been reaching into the 8 and 9 month mark on a regular basis. The government's failure to immediately transport Mr. Larson to a BOP facility and his continued detention at the FDC violates his right under both the Insanity Defense Reform Act and his right to a speedy trial under United States Code, Title 18, Section 3161. To avoid both issues, the court should order the BOP to make a facility available within 7 days, transport Mr. Larson to that facility, and that BOP provide the court with a restoration evaluation by November 25th, 2024. If BOP fails to do either, the court should dismiss the case. 1. Relevant procedural history. The government filed an indictment alleging Mr. Larson violated United States Code Title 18, Section 844 Sub E, Counts 1 through 5 and 7, and United States Code Title 18, Section 875 Sub C, Count 6, on April 25th, 2024. DE1. Mr. Larson was arrested on May 1st, 2024. DE4. I think that was actually, I think I might be wrong, but I thought it was April 30th that he was actually arrested, and then he had his initial appearance on May 1st. But apparently his lawyer thinks he was arrested on May 1st. DE4, after Mr. Larson's arraignment, discovery, and detention hearings on May 10th, 2024. DE12, he was ordered detained. DE15, on May 23rd, 2024, both the government and Mr. Larson's counsel jointly filed a request for psychological evaluation. DE17, the court issued an order granting the motion the same day. DE18, Mr. Larson was transported to the FCI for his evaluation on May 30th, 2024. DE25-2, BOP filed its evaluation on July 11th, 2024, 42 days after Mr. Larson arrived for his evaluation. DE22, the BOP did not request an extension to complete the evaluation. DE25-2, the BOP found Mr. Larson to be incompetent. DE22, and the court ordered Mr. Larson committed to the custody of the Attorney General for a restoration examination and treatment on July 26th, 2024. DE26-2. 2. A comprehensive statutory scheme and Supreme Court case law limit pre-hospitalization confinement of incompetent defendants. Because the issues presented in this motion are complex, namely the interplay between the IDRA and STA, a review of the statutory scheme and precedent limiting Mr. Larson's pre-hospitalization custody is necessary for the court to understand and evaluate Mr. Larson's request for relief. A. The Insanity Defense Reform Act. The IDRA provides comprehensive rules and procedures governing the process for competency determinations and restoration of incompetent defendants to stand trial. It also imposes independent time limits on pretrial detention of incompetent defendants. Under the IDRA, the process begins with a request to determine a defendant's competency. Section 4241 Sub A. After the court finds there is a reasonable cause to believe that the defendant may presently be suffering from a mental disease or defect rendering him mentally incompetent, the court can order that a psychiatric or psychological examination of the defendant be conducted and that a psychiatric or psychological report be filed with the court pursuant to the provisions of Section 4247 Sub B and Sub C, Section 4241 Sub B, For that evaluation, the court must commit the person to be examined for a reasonable period, but not to exceed 30 days to the custody of the Attorney General. When they say the custody of the Attorney General, they mean the custody of the BOP. Section 4247 sub B, emphasis added. The director of the facility may apply for a reasonable extension, but not to exceed 15 days upon a showing of good cause. The additional time is necessary to observe and evaluate the defendant. Emphasis added. After the court receives their report and finds the person incompetent, the court is required to commit him to the custody of the Attorney General. Section 4241 sub D. At that point, the Attorney General must hospitalize the defendant at a suitable facility, and the time period for doing so is strictly limited. The Attorney General shall hospitalize the defendant for treatment in a suitable facility, 1, for such a reasonable period of time not to exceed 4 months as is necessary to determine whether there is a substantial probability that in the foreseeable future he will attain the capacity to permit the proceedings to go forward, and 2, for an additional reasonable period of time until A, his mental condition is so improved that trial may proceed if the court finds that there is a substantial probability that within such additional period of time he will attain the capacity to permit the proceedings to go forward, or B, the pending charges against him are disposed of according to law, whichever is earlier. Emphasis added. In other words, the IDRA strictly limits the mandated evaluation and restoration period that follows an incompetency finding to 4 months, and the IDRA provides only one exception to that 4-month limit. A court may extend the initial 4-month period for an additional reasonable period of time, but only if the court first finds that there is a substantial probability that within such an additional period of time the defendant will attain competency to permit proceedings to go forward. Section 4241 sub D sub 1 sub A, emphasis added. B, Jackson v. Indiana and the constitutional prohibition on limitless detention of incompetent defendants. The IDRA's time limit on the detention of incompetent defendants is not merely a statutory directive, it is a Supreme Court mandate. In Jackson v. Indiana, the Supreme Court struck down as unconstitutional an Indiana statute that permitted the state to detain incompetent defendants indefinitely based solely on their incompetence. As the citation right there, 1972. In doing so, the court warned the statutory scheme that permits any form of limitless detention of incompetent defendants likely will not pass due process muster, holding that the government cannot constitutionally commit a defendant for an indefinite period simply on account of his incompetency to stand trial on the charges filed against him. Instead, Jackson held the applicable statutory scheme must limit such detentions both in time, by requiring that custody for a restoration assessment be limited to a reasonable period of time, and in scope, by requiring the confinement at all times bear a reasonable relationship and further the goals of competency restoration. See id at 738 to 39. At the least, due process requires that the nature and duration of commitment bear some reasonable relation to the purpose for which the individual was committed. It at 738. Congress enacted Section 4241 in direct response to Jackson, and specifically to ensure that the federal statutory scheme governing the confinement of incompetent defendants did not deny a person's due process rights. And then he has, I think, a special report number that he referenced from the 98th Congress. And he's got some more Ninth Circuit case law. And some 11th Circuit case law, right? As both the statute's text and history make clear, the point of Section 4241's 4-month period was to delineate the reasonable period described in Jackson and to prohibit limitless detention of defendants once they have been deemed incompetent. See Strong. And then there's the citation. Thus, in compliance with Jackson, once a court finds a defendant incompetent to proceed and commits the defendant to the Attorney General's custody for restoration, the statute caps the amount of time the government may take to fulfill the limited purpose, setting 4 months as a maximum, but requiring at all times that the length of time be reasonable, both the initial evaluation period and any subsequent extension. Section 4241 sub D, United States v. Anderson, which is a 10th Circuit case from 2017. The language in Section 4241 sub D is unambiguous and mandatory. After finding that a defendant was mentally incompetent to stand trial, the district court was required to commit that defendant to the Attorney General's custody. C. The Speedy Trial Act. The STA sets the general limits on how long a case may take from start to finish, and as a result, how long a defendant may be detained pending trial. Under the STA, a defense trial must commence within 70 days from the date of information or indictment. See Section 3161 sub C sub 1. If a defendant is not brought to trial within the time limit required, the indictment shall be dismissed on motion of the defendant. Section 3162 sub A sub 1. The STA provides for certain exclusions from the 70-day limit related to mental competency. First, time does not count towards the 70-day limit if it arises from delay resulting from any proceeding, including any examinations, to determine the mental competency or physical capacity of the defendant. Section 3161 sub H sub 1 sub A. Importantly, though, the Act separates from that the general exclusion of any time relating to transporting a defendant to a destination related to competency, treatment, or assessment. Specifically, the Act provides that delay resulting from transportation of any defendant to and from places of examination or hospitalization are excluded from the 70 days, but only up to 10 days from the date of the order that directed the examination or hospitalization, with any time in excess of 10 days presumed unreasonable. Section 3161 sub H sub 1 sub F. Emphasis added. Finally, the STA includes a separate provision excluding any period of delay resulting from the fact that the defendant is mentally incompetent or physically unable to stand trial. Section 3161 sub H sub 4. 3. The government's authority to detain Mr. Larson for Section 4241's evaluation/restoration period will expire no later than November 25th, 2024. The 4-month time limit specified in Section 4241 sub D sub 1 is unyielding and unambiguous. Unlike some other timeframes set by the IDRA, e.g. Section 4247 sub D, there are no allowances for extensions upon a showing of good cause. After the 4 months have expired, the court may extend Mr. Larson's commitment only if the court finds there is a substantial probability that within such additional period of time he will attain the capacity to permit the proceedings to go forward. Section 4241 sub D sub 2 sub A. The BOP's time to evaluate Mr. Larson and submit a report regarding its evaluation will expire no later than November 25th, 2024. To avoid this problem, the court should order the BOP to designate a facility within the next 7 days, immediately transfer Mr. Larson to that facility for examination/restoration services, and the BOP provide its report regarding its evaluation no later than November 25th, 2024. A. The Attorney General will lose its authority to hold Mr. Larson. Again, when they say the Attorney General, they just mean federal custody, like, in the BOP or whatever, being held in relation to this case, right? Because the IDRA only grants the government 120 days to evaluate Mr. Larson, the Attorney General's authority to detain Mr. Larson further will expire on November 25th, 2024. At this point, the Attorney General's only authority to detain Mr. Larson is the authority provided in the IDRA. It goes without saying, if the Attorney General squanders the authority granted by the IDRA, it will lose its authority to detain Mr. Larson at all. If the Attorney General has no authority even to detain a man, certainly it cannot ask to illegally detain him further. And we got footnote 2 right here. Let me read you footnote 2. If the Attorney General has no authority even to detain a man, certainly it cannot ask to illegally detain him further. Confer United States v. Charters, 4th Circuit case from 1987, on rehearing, 4th Circuit 1988. Reversing forcible medication order because the defendant's federal custodians do not at present have legal authority to detain Charters because procedures mandated by federal statutes governing detention of the mentally ill in federal facilities have not been followed, and concluding that if the federal government has no authority even to detain a man, it certainly cannot forcibly inject him with chemicals which may well be dangerous and mind-altering short of an emergency requiring such intrusion. So that gives a little backstory of where that quote originated that Danny's lawyer is using. Now, where was I? Okay. That alone will render Mr. Larson's continued detention after that date in BOP custody unlawful. The date upon which the IDRA's 4-month custodial commitment period begins to run, at commitment or hospitalization, has received scant analysis in this district. It has been an issue I think that's meant to say in 2 district court cases. First, in United States v. Moore, case number 106CR 235, District of Colorado 2006, and recently in United States v. Castrellon, case number 122CR 112 GPG, District of Colorado 2023. Judge Blackburn's order in United States v. Moore, case number 106CR 235, District of Colorado 2006, is instructive. Judge Blackburn, presented with the same issue, found the IDRA's 4-month period began once the court entered its order committing the defendant to the custody of the Attorney General. Judge Blackburn found that the 4-month period runs from the date of the commitment order because it is necessary to preserve the expedited process intended by Congress and to eschew administrative prolongation through control of the delivery of the person to the appropriate hospital. DE 61 attaches Exhibit A thereto. Another court in this district recently found that although the 4-month period began running only after the defendant was actually hospitalized, a pre-hospitalization commitment period of 6 months and beyond is unreasonable. United States v. Castrellon, case number 122CR 112 GPG, District of Colorado 2023, citing Donnelly, we do not think Jackson's reasonable relation requirement permits a pre-hospitalization commitment period whose purpose is simply to identify an appropriate treatment facility and arrange for the defendant's transportation to that facility to last longer than the maximum time Congress permitted for the period of hospitalization itself. Judge Gallagher dismissed the indictment against Mr. Castrellon, finding that a lesser sanction will not address the significant wrongs inflicted upon defendant in this case, nor will remedy the behavior of the government to ensure the timely hospitalization of incompetent defendants. DE 68 attached as Exhibit B thereto. Judge Blackburn cited a Sixth Circuit case to support his straightforward analysis of Section 4241 sub D sub 1's time limitations. In United States v. Baker, the Sixth Circuit held that the 4-month clock begins to tick upon the entry of the order committing a defendant to the custody of the Attorney General. Baker. We hold that, 1, the district court's initial commitment of Baker was valid only up to a period of 4 months. After a competency hearing, the district court found Mr. Baker incompetent and, pursuant to Section 4241 sub D, placed him in the custody of the Attorney General. It at 1318, punctuation omitted. Mr. Baker was confined in the custody of the Attorney General for 6 months after he was found incompetent. The Sixth Circuit held Section 4241 sub D requires that a determination as to the individual's mental condition be made within 4 months, and that the individual cannot be held pursuant to Section 4241 in excess of 4 months unless the court finds that the individual is likely to attain competency within a reasonable time. That's from Baker, which is a Sixth Circuit case from 1986. Because Mr. Baker was held from September 30th, 1985 until March 1986, before the government filed a motion to dismiss the probation violator's warrant. This confinement was clearly in excess of 4 months, and there's nothing in the record to indicate that his period of confinement was properly extended. Therefore, although the court's initial commitment of appellant on September 30th was valid, we hold that there was no authority to confine appellant beyond the 4 months authorized by Section 4241 sub D. Just to kind of explain the semantics, appellant means somebody who's appealing a case. Obviously, this is from the Sixth Circuit Court of Appeals. This is the Sixth Circuit's opinion as relating to a guy named Mr. Baker, which Daniel Larson's lawyer is relying on as a kind of precedent or authority to kind of back his argument, right? It at 1320. A well-reasoned 2022 opinion by Judge Friedrich of the U.S. District Court for the District of Columbia is also instructive. In that case, United States v. Carter, Judge Friedrich persuasively rejected the government's appeal for indefinite detention of incompetent defendants under the IDRA and rightly construed Section 4241 sub D sub 1's 4-month limit is starting from the moment that the defendant is committed to the Attorney General's custody, not at the point that the defendant finally is placed in a suitable facility for treatment. There's the citation. It's from the District Court for the District of Columbia, 2022. Key to Judge Friedrich's analysis was his rejection of the government's argument that once a defendant has been deemed incompetent, by the way, the government means, if you haven't noticed at this point, the prosecutor, right? Once a defendant has been deemed incompetent, Section 3161 sub H sub 1 sub F's 10-day limit on transporting a defendant to hospitalization no longer applies, and the Speedy Trial Act clock instead is indefinitely paused under Section 3162 sub H sub 4, id at 98 and 101. Judge Friedrich previously had adopted the government's view on that construction of the Speedy Trial Act, but noted that doing so required her to construe the IDRA as limiting that time instead. In denying the defense's speedy trial motion, this court explained that the Speedy Trial Act and IDRA work together to require the timely resolution of cases like this one, whereas the Speedy Trial Act requires the parties to work quickly before a finding of incompetence. The IDRA requires the government to work quickly thereafter. The government's reading of Section 4241 sub D sub 1, however, would create a substantial hole in this statutory scheme. Under that reading, defendants in Carter's position would lack any statutory recourse against potentially indefinite delays in transporting them to a suitable facility. It is hard to imagine that Congress, which passed Section 4241 to codify the Supreme Court's due process precedents, intended such a result. It at 101. In other words, if the government wishes to free itself of the Speedy Trial Act's limitations on transport delays by arguing that a defendant's incompetence halts the Act's clock indefinitely, it must accept the limits imposed by the IDRA. Otherwise, the statutory scheme would permit indefinite commitment based solely on incompetence, which neither comports with congressional intent nor the constitutional guarantees articulated in Jackson. That view is supported by the plain text of the statute as well. Again, as Judge Friedrich explained, the plain text of Section 4241 sub D sub 1 provides that the government shall hospitalize an incompetent defendant as soon as the government obtains custody over him. The government obtained custody over the defendant within the meaning of that provision. And Section 4241 sub D sub 1 does not mention delays in transporting defendants for hospitalization, let alone subject them to a different timetable. Accordingly, to the degree that Section 4241 sub D sub 1 allows the government to delay defendants' transportation, those delays must be part of the reasonable period of time not to exceed 4 months. Likewise, the government may not delay the 4-month deadline by detaining an incompetent defendant in a non-hospital setting. This question has received little analysis by the 10th Circuit or any other circuit. The 9th Circuit have issued, and by the way, the District of Colorado, where Daniel Larson is under the 10th Circuit, right? You have these district courts, usually it's several different districts in each state. Like you have, I don't know, for instance, the Middle District of Florida, Southern District of Florida, and Northern District of Florida, right? Florida has 3 different federal districts, right? But Colorado is one of those rare states that only has 1. But anyway, you have all these districts, and you have all these district judges, and then you have these circuits, which encompass several different states and all of the districts in them. And those are the federal appellate courts. You have the United States Court of Appeals for the First Circuit, United States Court of Appeals for the Second Circuit, United States Court of Appeals for the Third Circuit, and so on. Daniel Larson is in the District of Colorado. Colorado is in the 10th Circuit, which if he appeals his case will be heard by the United States Court of Appeals for the 10th Circuit, right? So you have an appeal from the district court. You have an appeal as of right to the United States Court of Appeals for whatever circuit you're in, right? An appeal as of right means that they have to hear your case, right? It's not discretionary. If you appeal it, the appellate court will issue a decision. It might take a while, but they will hear your case, right? So you have one appeal as of right. So Daniel, let's say if he wants to appeal his case, he can appeal he has that one appeal as of right. He has the right to appeal to the 10th Circuit. If the 10th Circuit's decision on his case is unfavorable, then he has the right to petition the United States Supreme Court for writ of certiorari, which is discretional. And the U.S. Supreme Court grants only about, I want to say less than 1% of the certiorari petitions that are submitted to it. So, like it's a discretionary court. The U.S. Supreme Court is a discretionary court. They do not have to hear every case, and they pick which cases they hear, unlike the 10th Circuit, which has to hear every appeal. So basically, if that helps explain, whenever you see circuit, it's the whatever Circuit Court of Appeals, and Daniel is in Colorado, which is the 10th Circuit, but there's not a lot of case law from the 10th Circuit on this situation, so his lawyer is using case law from other circuits, right? Anyway, this question has received little analysis by the 10th Circuit or any other circuit. The 9th Circuit issued an opinion in 2022, United States v. Donnelly, dealing with the Attorney General's authority to detain a person for Section 4241 sub D proceedings. Donnelly, however, punted on the specific issue of whether Section 4241 sub D authorizes any amount of pre-hospitalization confinement. Donnelly did state that it believed the text of Section 4241 sub D makes clear that the 4-month time limit applies only to the period of hospitalization and thus begins to run when the defendant has been hospitalized. Its belief was cabined, however. The court expressly did not decide whether Section 4241 sub D permits a delay between commitment and hospitalization. In fact, the panel went on to state that it did need not decide whether the statute allows some amount of pre-hospitalization confinement because the delay there falls outside of any constitutional reading of the statute. In other words, while the 9th Circuit found that while Section 4241 sub D's 4-month limit begins to run once the defendant arrives at the hospital, but it did not opine whether Section 4241 sub D authorized any amount of pre-hospitalization confinement before he actually arrives at that hospital. The implications of its decision, however, clearly impose at least a 6-month limitation on pre-hospitalization detention. Relying on Donnelly to support a finding that Section 4241 sub D's 4-month period begins once the defendant is received at the hospital, however, is problematic. Donnelly did not engage or answer the question of whether Section 4241 sub D permits a delay between commitment and hospitalization. If Section 4241 sub D does not permit any delay between the time the defendant is found incompetent and his arrival at the hospital, it necessarily imposes a 120-day limit on the amount of time the Attorney General is authorized to hold the defendant in pre-hospitalization confinement under the IDRA. As a result, the fact that Section 4241 sub D does not specify the amount of pre-hospitalization confinement that is permitted, coupled with any limitation Congress intended, would lead to the exact same result regardless of whether the 120-day period begins the day the person is received at the hospital or found incompetent. The Attorney General's authority to confine the person for the evaluation expires at day 120. Judge Waterford's concurrence in Donnelly makes this point clear. The 4-month period of confinement does not permit a delay between commitment and hospitalization, and the 120-day clock starts ticking the day the person is committed to the custody of the Attorney General to be evaluated. Watford concurring. Judge Waterford believed with... Let me just explain this to you real quick. When it says Waterford, J concurring, that means... what case is Donnelly from? Was that from the 9th Circuit? Hold on. Yeah. So Donnelly's from the 9th Circuit, right? So usually, unless it's an in-bank hearing, usually it's 3, so it's one judge in the district court, right? And then at the United States Court of Appeals, it's 3 judges, and then the U.S. Supreme Court is 9 judges, right? So when one of the appellate judges writes their decision, it has to be at least 2 people. Two of the 3 judges agree with that decision, right? If one of them doesn't agree, they can write a dissenting opinion. Or if one of them does agree, but they want to write their own opinion, they can write a concurring opinion, right? Meaning that their opinion concurs with the majority opinion, but they're writing separately to address, a different issue or whatever, right? So that's what it means. Judge Waterford concurring would be his opinion separate to, but concurring with the majority opinion in the Donnelly case, right? Anyway, Judge Waterford believed with Section 4241 sub D Congress plainly imposed 4 months as the outside limit on the entire period the defendant is committed to the custody of the Attorney General for treatment and evaluation, inclusive of any pre-hospitalization delay. He went on to write, nothing in the text of Section 4241 sub D suggests that Congress envisioned the creation of two separate time periods. The first, a period of pre-hospitalization commitment subject to no statutory time constraints whatsoever, to be followed by a period of hospitalization subject to a strict 4-month time constraint. The statute simply provides that upon finding the defendant not competent to stand trial, a district court shall commit the defendant to the custody of the Attorney General. In the same breath, the statute states that the Attorney General shall hospitalize the defendant for treatment and evaluation for a reasonable period of time, not to exceed 4 months. The provision is most sensibly read as imposing an outside time limit on the entire period of commitment, from issuance of the court's commitment order to completion of the defendant's period of hospitalization. See United States v. Carter, 2022, Westlaw 43636, page 5, District of Columbia, January 7, 2022. That is the view reflected in the statute's legislative history, which makes no mention of two separate time periods, but instead describes a single period of commitment under Section 4241 that may not exceed 4 months. Blah, 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 blah. And he quotes this Ninth Circuit case from 2007, reading the statute the same way. It seems plain to me from the text and legislative history that Congress assumed the defendant would be hospitalized in short order following his commitment to the custody of the Attorney General, such that 4 months would afford adequate time for the entire evaluation process to be completed. Judge Waterford's answer to the question of how much pre-hospitalization confinement Section 4241 sub D sub 1 authorized, therefore, was simple: none. He would have held Congress intended Section 4241 sub D sub 1's 4-month time limit to apply to the entire period of confinement, not just the period of hospitalization. He recognized at the time Congress enacted Section 4241 sub D, it anticipated the very problem presented here, the limitation of pre-hospitalization confinement based on the space at a suitable hospital. Congress specifically authorized the Attorney General to contract with a state, a political subdivision, a locality, or a private agency for the confinement, hospitalization, care, or treatment of, or the provision of services to a person committed to his custody pursuant to this chapter, Section 4247 sub I sub A, at 1108 to 09, based on the authority the IDRA grants Attorney General to contract with other providers. Congress envisioned only a short gap between issuance of a commitment order under Section 4241 sub D sub 1 and the defendant's hospitalization. The IDRA is detailed, specific, and comprehensive. It tracks every step of the competency process from initial competency determination to the moment a defendant is deemed unrestorable, at which point the criminal case ceases to justify the defendant's detention. And that 3-step process enacted by Congress expressly incorporates the rule of reasonableness. United States v. McCown, 5th Circuit, 2019. There is no reason to believe that Congress envisioned a secret, unregulated step in the middle of that process that is fully unmoored from Jackson's reasonableness mandate, during which an incompetent defendant may simply languish in a local facility indefinitely, waiting for the Attorney General to fulfill its statutory duty to complete a restoration assessment simply because he is incompetent. Put another way, nothing in the text of Section 4241 sub D suggests that Congress envisioned the creation of two separate time periods. The first, a period of pre-hospitalization commitment subject to no statutory time constraints whatsoever, to be followed by a period of hospitalization subject to a strict 4-month time constraint. Donnelly, blah, 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 Watford, concurring. That obvious reading of the statute places the IDRA in full harmony with due process. Of course, a fundamental canon of statutory construction is that where an otherwise acceptable construction of a statute would raise serious constitutional problems, a court should construe the statute to avoid such problems unless such construction is plainly contrary to the intent of Congress. See Edward J. DeBartolo Corporation v. Florida Gulf Coast Building and Construction Trades Council, which is a U.S. Supreme Court case from 1988. That canon, combined with clear congressional intent to comply with Jackson, means, as the Seventh Circuit has explained, that one of the guiding principles to interpreting the Insanity Defense Reform Act is that commitment proceedings pursuant to the statute must comport with due process. United States v. Shawar, Seventh Circuit, 1989. And that is exactly what the IDRA does. As both the statute's text and history make clear, the point of the Section 4241's 4-month period was to delineate the reasonable period described in Jackson and to prohibit limitless detention of defendants once they have been deemed incompetent and in need of restoration assessments. Once a court finds the defendant incompetent to proceed and he is placed in the custody of the Attorney General on that ground, the statute imposes an unequivocal cap on the amount of time the government may take to fulfill the limited purpose of determining the probability of restoration. Congress requires the government to both undertake and complete a restoration assessment within 4 months. Indeed, that 4-month limit and the reasonable relation it must bear to the purpose for which the individual is held have been central to decisions in other circuits determining IDRA commitment constitutional. In contrast to the statute at issue in Jackson, the duration of commitment under Section 4241 sub D is inherently limited. Aside from the statutory cap of 4 months, the length of custody is restricted to such a reasonable period of time as is necessary to determine whether the defendant will attain sufficient capacity in the foreseeable future. McCown and United States Code, Title 18, Section 4241 sub D. That is critical because Section 4142 sub D commitment is mandatory. As the Fifth Circuit has explained, Jackson allows the automatic imposition of confinement so long as the custody is not indefinite. McCown emphasis added. In other words, a statute that imposes mandatory commitment upon a finding of incompetence is unconstitutional if the statute does not impose a strict, statutorily imposed time limit on the period that follows the incompetency determination. That is what distinguishes the federal scheme from the Indiana statute struck down in Jackson. In at 726, Jackson involved an Indiana statute that, unlike the federal scheme, authorized the indefinite confinement of an incompetent defendant without an evaluation of his dangerousness or ability to attain competency through custodial care or compulsory treatment. McCown, blah, 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 emphasis added, alterations in original, quoting Jackson, blah, blah, blah. Accordingly, the Attorney General's authority to detain Mr. Larson for purposes of the restoration assessment mandated by Section 4241 sub D began on July 15, 2022 and will end on November 25, 2022. I think that's obviously a mistake. He meant to write 2024. The Attorney General has no authority to hold Mr. Larson in his custody beyond that point, and no further action could be taken under Section 4241 sub D. This court should order the BOP to designate a facility within 7 days, immediately transport Mr. Larson to that facility, and file the appropriate report by November 5th, 2024. B. Mr. Larson's continued detention would be patently unreasonable if he is not immediately transported to a suitable facility. Accepting the view that IDRA's 4-month time period only begins the moment the government finally physically places Mr. Larson in a suitable hospital facility, allowing the Attorney General to continue to confine him indefinitely before he's transported to a hospital is unlawful because that pre-hospitalization confinement is patently unreasonable under IDRA and Jackson. As discussed above, Donnelly examined whether the amount of time the Attorney General is authorized to detain a person under Section 4241 sub D sub 1. Critically, all 3 judges in Donnelly agreed the 6 months that the defendant sat in jail waiting to be transported to a suitable medical facility was unreasonable in violation of the IDRA in Jackson. The court explained the Constitution does not permit any portion of a defendant's commitment under Section 4241 sub D to last indefinitely. The court then interpreted IDRA's extensive reasonableness language, referencing Jackson, to set an implicit limit on how long the government may hold a defendant in local custody before actually undertaking its statutory duty to restore him. The court found the 6 months the defendant had been detained crossed the reasonableness line. We do not think Jackson's reasonable relation requirement permits a pre-hospitalization commitment period whose purpose is simply to identify an appropriate treatment facility and arrange for the defendant's transportation to that facility to last longer than the maximum time Congress permitted for the period of hospitalization itself. Thus, we have little difficulty concluding that wherever the outer limit of Section 4241 sub D, the length of Donnelly's confinement, exceeds it, the fact is even more evident today as Donnelly has now been held in the pre-hospitalization custody of the Attorney General for more than 8 months, twice as long as the maximum period Congress authorized for the entire length of a defendant's hospitalization. Donnelly, blah, 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 there's a citation. Having found a violation of the statute, the Ninth Circuit ordered that the defendant be transported to a medical facility within 7 days. Even if this court determines that IDRA's 4-month commitment period does not commence until the moment Mr. Larson sets foot at a facility, Jackson mandates the IDRA impose some limit on the entire period Mr. Larson has been detained following his incompetency finding. Indeed, neither Jackson nor by extension the IDRA permit that period to be indefinite. Instead, by the IDRA's express terms, the period must be reasonable. Confer United States v. Wada, 4th Circuit 2020, finding that a 6-month period in which the government failed to act following a finding of unrestorability was not reasonable. Moreover, and critically here, Mr. Larson's continued pre-hospitalization confinement, which might be 5 months, is patently unreasonable. It would be more than double the reasonableness benchmark set by Congress and the IDRA, which Donnelly found unreasonable. And none of that time has any relationship whatsoever to accomplishing the evaluated mandated by Section 4241 sub D. Plug in real quick. Hold on. Give me a sec. It is worth noting, too, that this is not an isolated problem, making the delay in this case even more unreasonable. Indeed, the government has been engaging in this conduct for at least a decade, subjecting defendants to lengthy pre-hospitalization confinement without assessment or treatment because there is a bed space shortage. And FMC Butner was to blame. Little trivia in there. FMC Butner is actually where Ted Kaczynski died. I think Bernie Madoff died there, too, as a matter of fact. Let me see. Hold on. I just got a text. Okay. I'm sorry. Where was I? Indeed, the government has been engaging in this conduct for at least a decade, subjecting defendants to lengthy pre-hospitalization confinement without assessment or treatment because there is a, quote, bed space shortage, and FMC Butner was to blame. Courts long have identified this as an issue. We got footnote 3. Let me read you footnote 3. C.E.G. United States v. Smith, Western District of New York, 2011, observing over a decade ago an identical problem with lack of available beds at BOP medical facilities for competency restoration and the government's inability to provide even an estimate of when a bed would become available. That's the end of footnote 3. Moreover, in the speedy trial context, courts have made clear that resource shortages, i.e. failure to allocate proper resources for statutory duties, do not justify refusal to comply with legislative mandates. E.g. United States v. Castle, 5th Circuit, 1990. And despite its knowledge of lengthy delays and shortages at BOP, the government repeatedly refuses to pursue local alternatives under Section 4247, sub I, sub A. And then we have footnote 4 right here. Let me read you footnote 4 real quick. Colorado has a statutory system for civil commitment of incompetent individuals. See Colorado Revised Statutes 2765-101 at sec because Colorado has a system for providing effective care, custody, and treatment to incompetent individuals. Federal civil commitment under Section 4246 is unnecessary. End of footnote 4. Permitting Mr. Larson to remain in custody beyond Section 4241 sub D's, a 4-month limit before he is even transported to a suitable facility is unlawful. Such detention would fail to satisfy the IDRA and Jackson's reasonableness requirement. See, the STA will be violated. The STA sets general limits on how long a case may take from start to finish, and as a result, how long a defendant may be detained pending trial. Under the STA, a defendant's trial must commence within 70 days from the date of the information or indictment. See Section 3162 sub A sub 1. The STA permits specified exclusions from the 70-day limit related to mental competency. First, time does not count toward the 70-day limit if it arises from delay resulting from any proceeding, including any examinations to determine the mental competency or physical capacity of the defendant. Section 3161 sub H sub 1 sub A. The STA also includes a separate provision excluding, quote, any period of delay resulting from the fact that the defendant is mentally incompetent or physically unable to stand trial. Section 3161 sub H sub 3 sub 4. Importantly, though, the Act separates from that general exclusion any time related to transporting a defendant to a destination related to competency, treatment, or assessment. Specifically, the Act provides that delay resulting from transportation of any defendant to and from places of examination or hospitalization are excluded from the 70 days, but only up to 10 days from the date of the order that directed the examination or hospitalization, with any time in excess of 10 days presumed unreasonable. Section 3161 sub H sub 1 sub F. Any attempt to evade the STA's limits on indefinite detention of incompetent defendants rests on employing a strained reading of that statute's text and district court cases. Multiple district courts have persuasively held that the STA's transport limit applies not just to delays arising from initial competency evaluations, but to the period following an incompetency finding as well. Footnote 5. Read your footnote 5. Well, it looks like footnote 5 is mostly just quoting case law. United States v. Sparks, blah, blah, blah. You can see all these case law. United States v. Bauer, which is from District of D.C., 2003, rejecting the government's arguments that Section 3161 sub H sub 1 sub A permits blanket transportation delays. That's the only description written for any of these cases in the footnote. So, anyway, that's footnote 5 right there. The ongoing delay in this case following the court's order is not the result of Mr. Larson's incompetence. It is the result of the government's failure to effectuate the court's order and statutory obligation to transport Mr. Larson to a suitable place of hospitalization. Compare Section 3161 sub H sub 1 sub F, governing any delay resulting from transportation to and from places of examination or hospitalization, with Section 3161 sub H sub 4, governing any period of delay resulting from the fact that the defendant is mentally incompetent or physically unable to stand trial. Man, I got really bad heartburn today. I don't know why. 4. The proper remedy is ordering the BOP to immediately designate a facility, transport Mr. Larson to that facility, and submit its report by November 25th, 2024. Mr. Larson cannot be detained indefinitely to determine if he can be restored. One district court in the 10th Circuit tracks almost perfectly. In United States v. Lusogi, District of Utah, 2022, the court ordered the defendant transferred to FMC Butner. Again, I told you about a little of the lore with Ted Kaczynski and Bernie Madoff. Within 7 days after finding the IDRA's 4-month period had been violated and following Donnelly's remedy. The government was unable, however, to comply with the court's order and have the defendant transferred within the 7 days. United States v. Lusogi, blah, blah, blah. The court promptly dismissed the case. It simply put, the judge put a strict deadline on the government's transfer of a defendant to a BOP facility because the time period had lapsed, and when the government failed to comply, it dismissed the case. The same thing will happen here if the BOP is not required to immediately designate a facility and transport Mr. Larson to that facility. The remedy for a STA violation would lead to the same result. If a defendant is not brought to trial within the time limit required by Section 3161 sub C, as extended by Section 3161 sub H, the information or indictment shall be dismissed on motion of the defendant. Section 3162 sub A sub 2, emphasis added. See exempli gratia, United States v. Olivis, blah, 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 Western District of Texas, dismissing the indictment on speedy trial grounds because the government failed to have the defendant transported for a reasonable evaluation. That's there's Daniel's lawyer's summary of that case. At this point, 32 days have elapsed. The clock will start running again on November 23rd, 2024, and will expire on December 31st, 2024. 5. Conclusion. Based on the foregoing, Mr. Larson respectfully requests the court to order the BOP to designate an appropriate facility within 7 days, transport Mr. Larson to that facility, and provide the court with its evaluation by November 25th, 2024. If the BOP fails to do either, the court should dismiss this case. Respectfully submitted this 25th day of September, 2024. Virginia L. Grady, Federal Public Defender, by Jared Scott Westbrook. Apparently, maybe it looks like Virginia Grady's one of the lawyers that works with Daniel. But anyway, that is the end of that motion. There's also some more pages, but the rest of the pages are just they're just copies of the case law that were cited in here, or some of the case law. So what does this mean? It was a pretty long-winded motion, but it can just be broken down basically to the fact that Daniel's lawyer is arguing under So right here I have Title 18 United States Code Section 4241, right? So we're going to go to 4241 sub D sub 1, right? Determination and disposition. If after the hearing the court finds by a preponderance of the evidence the defendant is presently suffering from a mental disease or defect rendering him mentally incompetent to the extent that he is unable to understand the nature and consequences of the proceedings against him or to assist properly in his defense, the court shall commit the defendant to the custody of the Attorney General. The Attorney General, which basically, the custody of the BOP, right? The BOP shall hospitalize the defendant for treatment in a suitable facility, one, for such a reasonable period of time not to exceed 4 months as is necessary to determine whether there is a substantial probability that in the foreseeable future he will attain the capacity to permit the proceedings to go forward. And you've probably heard about the Jackson case that they mentioned in there. Well, the Jackson case is an old Supreme Court case, U.S. Supreme Court case, where they said that criminal defendants, if they're found to be incompetent to stand trial, and it's found unlikely that they're going to become competent anytime soon, it's not constitutional to just hold them in jail just because they're incompetent. Hold them while waiting to basically, wait for them to become competent, right? So the institution, the federal prison that they're trying to transfer Daniel to is the Medical Center for Federal Prisoners in Springfield, Missouri. But the part that he needs to go to, like the psychiatric part, is, it's filled up and they don't have space for him. He's on the waiting list and they haven't been able to get him in yet. And his lawyer's basically saying, hey, Daniel's speedy trial rights are being violated if you've held him for, I don't know, how long has he been held since since he was found incompetent? I think he was found incompetent, I think I said July 11th, so August, September, October, over 3 months now. He's been waiting for a bed to open up in Springfield so he can get evaluated. And, this statute right here says, hey, he can only be evaluated for, up to 4 months. And his lawyer's saying he's been already waiting for 3 months to, go get this evaluation, which is, it's damn near what the maximum time for him to be examined is, 4 months. So his speedy trial rights are being violated, and this case should be dismissed. It's based on the BOP's negligence, not having enough space for him to go to Springfield right away and get examined. So that's basically the gist of that motion right there. Now I'm going to go read you what the prosecutor wrote in response to that motion. Okay, so here we are. This is the prosecutor's response to Daniel's lawyer's motion to basically the one that I just read you for to be transported to a suitable facility within 7 days, or get either in the alternate get the case dismissed, right? So this is the prosecution's response. It's significantly shorter. I think it's less than half as long as the defense's motion that I just read you was. But listen. Government's response to Daniel Larson's status report and request for immediate transport to a, quote, suitable facility, ECF number 29. And this, by the way, this was filed October 3rd, 2024. The United States of America, by and through undersigned counsel and counsel for the defendant, hereby files this response to the defendant's status report in compliance with the court's order, ECF 30, and states as follows. 1. Background. On April 25th, 2024, the defendant was indicted on 7 counts related to interstate threats pursuant to United States Code Title 18, Section 875 sub C and 844 sub E, ECF number 1. The defendant was arraigned on the charges in this case on May 10th, 2024, and ultimately detained by the court. On May 23rd, 2024, the parties filed a joint motion for evaluation on competency, ECF number 17. United States Code Title 18, Section 3161 sub H sub 1 sub D addresses the delay resulting from any pretrial motion on computing the time within which the trial of any offense must commence, and dictates that speedy trial then told during the pendency of the joint motion. The court ordered an evaluation on the same date, ECF number 18. The initial evaluation of the defendant found him to be incompetent, and on July 26, 2024, the defendant was committed to the custody of the Attorney General for a restoration, examination, and treatment pursuant to United States Code, Title 18, Section 4241, Sub D, ECF number 26. The provisions of United States Code, Title 18, Section 3161, Sub H, Sub 1, Sub A, and Sub 4 address the impact any delays related to the defendant's competency should have on time limits and exclusions for speedy trial. Therefore, speedy trial has continued to toll since the date the defendant's competency was raised by the court. The BOP designated the defendant to a suitable facility for restoration and further examination on August 1st, 2024, after receipt of the court's order on July 26, 2024. The defendant has been on the wait list for restoration and further examination at the MCFP Springfield Bureau of Prisons facility. A little lore with MCFP Springfield. That's actually where John Gotti died. The mafia, I think it was a mafia boss, wasn't he? Anyway, the defendant has been on the wait list for restoration and further examination at the MCFP Springfield Bureau of Prisons facility, a federal medical facility, FMC, which stands for Federal Medical Center, capable of these types of services since that date, and BOP's estimated transport date for the defendant based on bed availability is in December 2024. 2. Legal framework. In Jackson v. Indiana, the Supreme Court held that a person charged by a state with a criminal offense who is committed solely on account of his incapacity to proceed to trial, or in other words, incompetence to stand trial, cannot be held more than a reasonable period of time necessary to determine whether there is a substantial probability that he will attain that capacity in the foreseeable future. 1972, there's the U.S. Reporter citation. The Jackson Court concluded that the Due Process Clause mandated a rule of reasonableness. There, the Supreme Court found a due process violation where the defendant was committed until such time as the Indiana Department of Mental Health should certify to the court that the defendant is sane, and at that time had been confined for 3.5 years despite evidence demonstrating that he was unlikely to ever be able to participate fully in a trial. In response to Jackson, Congress enacted United States Code Title 18, Section 4241, see United States v. Megasuba, 2nd Circuit 2008, reciting statutory history. As relevant here, Section 4241 sub D states that upon a finding of incompetence, the court shall commit the defendant to the custody of the Attorney General. The following sentence provides that the Attorney General shall hospitalize the defendant for treatment in a suitable facility for such a reasonable period of time, not to exceed 4 months, as is necessary to determine whether there is a substantial probability that in the foreseeable future he will attain the capacity to permit the proceedings to go forward. United States Code Title 18, Section 4241, sub D, sub 1. The statute also permits a defendant's continued hospitalization for an additional reasonable period of time until his mental condition improves or the pending charges are disposed of. United States Code Title 18, Section 4241, sub D, sub 2, sub A to B. 3. Argument. A. Pursuant to the plain language of Section 4241, sub D, sub 1, the 4-month time period only begins to run when the defendant is hospitalized, which has not happened here. The defendant argues that Section 4241 sub D sub 1's 4-month time period starts upon commitment and therefore is currently running in this case. Not so. As set forth above, the plain language of Section 4241 sub D sub 1 ties the 4-month time period to a defendant's hospitalization, not his commitment to the custody of the Attorney General. This court's order is consistent with that statutory language. UCF number 26. Accordingly, the 4-month clock has not started in this case because the defendant has not yet been hospitalized at a federal medical center. Other courts have reached the same conclusion regarding whether the 4-month time period starts upon a defendant's commitment or hospitalization. In United States v. Megasuba, 2nd Circuit 2008, although the 2nd Circuit concluded that the government violated Section 4241 sub D sub 1's 4-month limit, in doing so it did not include the period of pre-hospitalization delay. See it at 408. We construe Section 4241 sub D sub 1 to impose a 4-month limit only on the Attorney General's authority to hold an incompetent defendant in custodial hospitalization for the purpose of determining the probability of his regaining competency. The District Court in the United States v. Gamara, the District of Columbia, District Court for the District of Columbia, 2018, relying on Megasuba, similarly concluded that the clear language of Section 4241 sub D sub 1 refers to the period of time for which the defendant is actually hospitalized. Nowhere does it refer to the date on which a court orders the hospitalization as the date from which that period starts. Gamara, blah, blah, blah. The district court therefore determined that the defendant's statutory period of confinement began on September 19, 2017, when he was actually hospitalized. Even the Ninth Circuit's decision in the United States v. Donnelly, 2022, despite finding excessive pre-hospitalization delay, did not conclude that Section 4241 sub D sub 1's 4-month limit starts upon commitment to the Attorney General's custody. See it at 1105, declining to decide whether this statute allows some period of pre-hospitalization delay, and instead concluding that the pre-hospitalization delay fell outside of any constitutional reading of the statute. Accordingly, because the defendant has not yet been hospitalized at a FMC, his argument that the 4-month time period is running is unavailing and does not warrant the relief he now seeks. Nor does United States v. Carter, District of Columbia 2022, on which the defendant lies, warrant a different conclusion. Although the district court there concluded that the failure to transport the defendant to a facility for evaluation within 4 months violated Section 4241 sub D, that result is contrary to Megasuba, Gamara, and the statutory text of Section 4241 sub D. The court in Carter, without much explanation, interpreted Section 4241 sub D as requiring the government to hospitalize the defendant as soon as the government obtains custody over him. As set forth above, that interpretation is not consistent with the plain, unambiguous language of Section 4241 sub D. Accordingly, this court should now decline to follow Carter as persuasive authority. See United States v. Bellegarde, District of North Dakota, 2022, declining to follow Carter as persuasive authority because court disagreed with Carter's statutory interpretation of Section 4241 sub D sub 1. This is not to say that the defendant could be held in indefinite pre-hospitalization limbo. Jackson prevents that result. See Jackson at 731, holding that states indefinite commitment of a criminal defendant solely on account of his incompetency to stand trial does not square with the 14th Amendment's guarantee of due process, and that is not a concern here, where BOP has stated that the defendant will be transported and hospitalized for competency restoration in December 2024. B. This court's order is sufficient to trigger the necessary transport of the defendant. The defendant further seeks an additional order trying to speed up the process of the defendant's restoration and evaluation. The court's order at ECF number 26 has already resulted in the defendant being designated to an FMC. The BOP is actively working to make bed space available for the defendant, and the defendant has provided no reason or authority upon which this court can or should rely to order the BOP to transport the defendant any faster or remove other defendants from the FMC that is qualified to evaluate the defendant. 4. Conclusion. Based on the above case law and statutory interpretation, the defendant is wrong in his assertion that the BOP's time to evaluate the defendant expires on November 25, 2024. The plain language of the statute provides that the 4-month time period begins upon the defendant's hospitalization, which will begin in December 2024. Dated this 3rd day of October 2024, respectfully submitted Matthew T. Kirsch, acting U.S. Attorney by Allison Conity. Okay, I get what it is. That's the head of the prosecutor's office, and that is the prosecutor that's actually on the case, right? We go back over to this one. This is the head honcho who had nothing to do with the writing of this motion, and then this is, who actually wrote the motion. I was mistaken when I said that this was like a law intern or whatever. But yeah, I mean, that should be pretty self-explanatory. The prosecutor is saying that, the defense is trying to say that, hey, he's been, like I told you, his speedy trial rights are being denied because of he's being basically held for almost as much time. But when it gets to December, it'll be more time. Right, the statute for that says how long he can be held to be examined to see if he will regain competency anytime soon says he can only be held for 4 months, and his lawyer saying, hey, he's being held in jail on a wait list for more than 4 months, which is insane. And then now the prosecutor is firing back and saying, hey, we don't think that the amount of time that he's waiting is unreasonable. And the 4 months doesn't start until Daniel gets to Springfield, right? So, basically saying, obviously they're not going to agree with the defense's motion, and they're saying that, Daniel's lawyer's wrong, right? But now I'm going to read to you the judge's decision. After hearing both these motions and being briefed on the issues, I will read you the judge's decision right now. Okay, here we are. This is the judge's opinion and order that was filed on October 9th. So about, what's today? So about, 10, 11, 12. Less than 2 weeks ago, though, I think. I'm not great at math, but it's definitely less than 20 days ago, right? So very recent. I don't even know what day it is today, honestly. But anyway, here we go. This matter is before the court on the defendant's status report and request for immediate transfer to a, quote, suitable facility, the motion ECF number 29. The court has considered the government's response, ECF number 31. Again, these are the document numbers on the docket of the case, and the entire record in this case. For the reasons discussed below, the court will deny the motion without prejudice. Now, usually I wait till the end to kind of explain stuff, but what does it mean without prejudice? It means that this can be brought back up again. If you didn't say, say there's a bail motion, right? Somebody moves for, if they're being held with no bond, and they file a motion to get a bond, right? And the court says, usually this doesn't happen, but the court says the motion is denied with prejudice, right? With prejudice means you can never bring up the motion ever again. If the court says, the motion is denied without prejudice, that means, well, I'm denying it right now, but you can bring the issue back up again. There's also, you use that for dismissals. Like if a case is dismissed with prejudice, it means it can't be brought back up again. If a case is dismissed without prejudice, it can be brought up again absent any, other circumstance that would stop it from being brought back up again. Like, like the statute of limitations is up or whatever. But anyway, background. On April 24th, 2024, defendant was charged by indictment with 6 counts of violating United States Code Title 18, Section 844. Hold on, I just got a text. Sub E, use or threatened use of explosive material, and 1 count of violating. Who keeps text? God damn. Violating United States Code Title 18, Section 875, Sub C, communicating a threat. ECF number 1. On May 1st, 2024, defendant was arrested and has been detained ever since, ECF number 15. On May 23rd, 2024, counsel for the parties filed a joint motion for a psychological/psychiatric evaluation, ECF number 17, to determine whether defendant was both competent at the time of the alleged offenses in the indictment and whether he is currently competent to aid counsel in this defense of this case. Defendant was the subject of a forensic evaluation, ECF number 22. This evaluation concluded that defendant is not currently competent to proceed with his case and that he is not currently competent to waive his right to trial in a knowing, voluntary, and intelligent manner. On July 11th, 2024, the parties jointly filed a motion requesting court finding on competency, ECF number 24. On July 26th, 2024, the court ordered the defendant be committed to the custody of the Attorney General to hospitalize the defendant for treatment in a suitable facility for such a reasonable period of time not to exceed 4 months as is necessary to determine whether there is a substantial probability that in the foreseeable future he will attain the capacity to permit the proceedings to go forward. Fat chance. Pursuant to United States Code Title 18, Section 4241, Sub D, ECF number 26. On September 25th, 2024, defendant filed the instant motion. The motion indicated that, despite the court's order 2 months prior that defendant be transported and hospitalized for a term of no more than 4 months, defendant remained in the federal detention center. The motion states that the Bureau of Prisons, BOP, has yet to designate a facility for Mr. Larson'S restoration evaluation because it has a backlog of inmates waiting for restoration services, ECF number 29 at 1. Defendant argues that the Insanity Defense Reform Act, IDRA, strictly limits the mandated evaluation and restoration period that follows an incompetency finding to 4 months, and that the BOP's time to evaluate Mr. Larson and submit a report regarding its evaluation will expire no later than November 25, 2024. 8.4.6 emphasis in the original. Defendant also argues that the Speedy Trial Act, United States Code Title 18, Section 3161, will be violated if he is not immediately transferred to a suitable facility. Defendant argues that the Speedy Trial clock will start running again on November 23, 2024, and will expire on December 31, 2024. Defendant seeks an order requiring he be transferred to a suitable facility within 7 days, and the BOP provide the court with its evaluation by November 25, 2024. Defendant argues that if the BOP fails to do either, the court should dismiss the case. In response, the government argues that the 4-month period described by United States Code Title 18, Section 4242 sub D sub 1 has not yet begun to run because the period only begins to run when defendant is hospitalized, which has not yet happened. ECF number 31. The government also states that the BOP designated the defendant to a suitable facility for restoration and further examination on August 1st, 2024, and BOP's estimated transport date for the defendant based on bed availability is in December 2024 at 2. We already know all this, right? 2. Discussion. A. IDRA. The IDRA sets out the procedure courts must follow when a defendant's competency is called into question. The statute provides that the court shall commit the defendant to the custody of the Attorney General, and that the Attorney General shall hospitalize the defendant for treatment in a suitable facility for such period of time not to exceed 4 months to determine whether the defendant's competence can be restored. United States Code Title 18, Section 4241 sub D sub 1. The statute provides that if, at the end of that period, the defendant's competence is not restored, the defendant will typically be discharged to state authorities for further care and treatment. Id citing United States Code Title 18, Section 4246 sub D. The question is whether the 4-month statutory cap under Section 4241 sub D sub 1 begins only once the defendant is admitted to a facility for treatment and diagnosis. This court agrees with the analysis in United States v. Castrellon, 2023 Westlaw 2330688, page 3, District of Colorado, March 1st, 2023, blah, 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 which relies on the analysis in U.S. v. Megasuba, 2nd Circuit 2008, and U.S. v. Donnelly, 9th Circuit 2022, for its finding that the 4-month period in Section 4241 sub D begins running upon the hospitalization of the defendant. Therefore, no violation of Section 4241 sub D sub 1 will occur if defendant is not evaluated by November 25th, 2024, 4 months from this court's order on July 26, 2024, because defendant has not yet been hospitalized to begin the restoration process. However, in Jackson v. Indiana, 1972, the Supreme Court made clear that a person charged with a criminal offense who was committed solely on account of his incapacity to proceed to trial cannot be held more than the reasonable period of time necessary to determine whether there is a substantial probability that he will attain that capacity in the foreseeable future. The question becomes what a reasonable period for pre-hospitalization confinement is. In Donnelly, the 9th Circuit determined 8 months of pre-hospitalization commitment was too long and remanded the case back to the district court with instructions to order the Attorney General to hospitalize the defendant within 7 days. We make no ruling as to the maximum allowable length of a pre-hospitalization commitment period, but hold that the 8 months Donnelly has waited to be hospitalized in a suitable facility plainly exceeds whatever period the statute conceivably allows. Within the 10th Circuit, a district court ordered the Attorney General to transport the defendant to a suitable facility within 7 days after waiting in pre-hospital confinement for over 4 months from June to October 2022. Rather than grant the defendant's motion to dismiss the indictment. United States v. Lusaugi, District of Utah, 2022. The district court judge ultimately dismissed the indictment less than a month later because the defendant was not likely to be transferred until February 2023, which would have required the defendant to be incarcerated for 8 months, awaiting transfer, a time period the 9th Circuit has deemed to violate a defendant's statutory rights under the IDRA. United States v. Lusaugi, blah, blah, blah. Another case in this district presents the same facts as Mr. Larson's situation. The defendant was determined to be incompetent on July 15th, 2022, and in December 2022, The government filed a status report saying the defendant had been designated to a facility on July 22, 2022. Still, because of the wait, he would not be transported until early April 2023. Defendant filed a motion to dismiss. The magistrate judge recommended denying the motion to dismiss, but warned if Mr. Castrellon is not assigned to a suitable facility and beginning treatment by April 10, 2023, this court, like the court in Donnelly, would then strongly entertain dismissing the indictment at that time. Castrellon, at 4, there's the Westlaw citation, page 4. Defendant renewed his motion to dismiss because defendant was not transported until April 18th, 2023, after the April 10th, 2023 deadline. This time, the district court granted the motion to dismiss, finding that the pre-hospitalization commitment period of 6 months and beyond is unreasonable. Castrellon, citing Donnelly. Here, the government has represented that the estimated transport date for defendant is December 2024. If defendant is transported by the end of December 31st, 2024, he will have spent a little over 5 months awaiting designation to a medical facility. 5 months is less than the 8 months found to be unreasonable in Donnelly and Lusogi. It is also less than the 6 months found to be unreasonable in Castrellon. Rather than enjoin the government to effectuate the immediate hospitalization of defendant, the court will do as the court in Castrellon did and hold the government to its representation. If defendant is not transported to a suitable facility for treatment by December 31st, 2024, this court would strongly entertain dismissing the indictment at that time. B. Speedy trial. Defendant contends that the speedy trial clock will start running again on November 23rd, 2024, and will expire on December 31st, 2024. ECF number 29, page 19. Generally speaking, the Speedy Trial Act requires that a defendant be brought to trial within 70 days of his indictment. United States Code Title 18, Section 3161, sub C, although that time period is subject to a wide array of circumstances that toll the 70-day clock. C. United States Code Title 18, Section 3161, sub H. United States Code Title 18, Section 3161, sub H, sub 4 provides that the 70-day clock is tolled for any period of delay resulting from the fact that the defendant is mentally incompetent to stand trial. United States Code Title 18, Section 3161, sub H, sub 1, sub F authorizes a tolling of the speedy trial clock for delay resulting from transportation of any defendant to and from places of examination of hospitalization, but which expressly provides that such tolling is limited to 10 days. Defendant argues that the ongoing delay is not a result of his incompetence, but rather the result of the government's failure to transport him to a suitable place of hospitalization. The court in Castrellon considered this exact argument and persuasively rejected it. There, the court found that the speedy trial clock was tolled from the time the court determined that the defendant was not competent to proceed to trial until his competency was restored pursuant to United States Code Title 18, Section 4241, sub D, sub 1, and sub 2. The court also found that the 10-day limit of Section 3161, sub H, sub 1, sub F is only appropriate when the Marshal Service fails to expeditiously transfer the defendant to an available facility rather than restrict the accommodation of medical facilities hampered by a limited bed space. Quoting U.S. v. Bashar, Eastern District of Virginia, 2014. Here, there's no showing that an appropriate facility is willing to accept the defendant, and that it is the Marshal Service that is delaying his transport. Rather, the delay is attributed to the lack of available bed space. Therefore, the 10-day limitation under Section 3161 sub H sub 1 sub F does not apply. This court determined on July 26, 2024, that the defendant is not competent to proceed to trial. Under United States Code Title 18, Section 3161 sub H sub 4, the speedy trial clock was tolled starting on July 26, 2024, and remains tolled until the defendant's competency is restored. As of right now, the court does not find that the defendant has suffered any deprivation of his statutory speedy trial rights. For the foregoing reasons, defendant's motion for immediate transfer is denied without prejudice. If defendant is not assigned to a suitable facility and beginning treatment by December 31st, 2024, this court, like the courts in Castrellon and Donnelly, would then strongly entertain dismissing the indictment at that time, dated October 9th, 2024, by the court Regina M. Rodriguez. So, what does that mean? I mean, it's pretty straightforward, right? If Daniel Larson is not transferred to MCFP Springfield by the end of this year, the judge will very likely dismiss the indictment against him, which means he'll just, get out of jail the charges are gone. He won't be in a mental hospital. He won't be in jail. He'll be back on the street, right? And also, it doesn't say. It just says this court would then strongly entertain dismissing the indictment at that time. It doesn't say if the court is entertaining dismissing the indictment with prejudice or without prejudice, right? Obviously, it's kind of a toothless sanction if this hypothetically, Daniel's not in Springfield by the end of the year, and the court, the judge dismisses the case without prejudice, right? It's like I said, it's a toothless sanction. The prosecution just has to refile it, and they only have the inconvenience of going through everything again, having another arraignment, another initial appearance, all that other stuff, another raising of competency, all that. If this judge decides to dismiss the case with prejudice, then they can never be brought back up, and Daniel's off the hook, at least for these federal charges, right? But I doubt that Daniel will not be in Springfield. Will not have been moved by then. I think he'll probably be moved by December. And once he gets moved, I doubt that he will regain. I doubt that they'll find that it's likely for him to regain competency anytime soon. And then I think it was in his lawyer's motion that said that state civil commitment proceedings are available, so he will be committed pursuant to Colorado state law. If he gets moved to Springfield before December 31st, and he is found unlikely to become competent anytime soon, right? They have 4 months to make that determination, and I don't think he will be found likely to become competent anytime soon, so then he will be civilly committed in Colorado state courts. So anyway, that's pretty much all I have for this video. I hope this helps you get a little bit more of an understanding of Larson'S case, and I got more calls with them coming, more interesting content coming, but anyway, thanks for watching. Like, comment, and subscribe if you're based like me, and until next time.